Your broader argument, as Justice Kagan points out, would suggest, I think, starting over in how the court analyzes this whole area. And maybe it's just out of sympathy for the district court judges and court of appeals judges who would have to deal with the fallout from that. But isn't a simpler way to deal with this just, and maybe this is your narrow argument, under the wholly collateral factor, a challenge to the structure of the agency is wholly collateral. End of story.
Well, I mean, with respect, I think the easiest way for the district courts to resolve this is to look at the text of what Congress enacted.
I know that, but there's a lot. My point is there's a lot of precedent interpreting that text. It's Thunder Basin, Elgin, Free Enterprise Fund, and going back. And so kind of starting over on all that would create a kind of a tsunami of litigation. Maybe that's okay, maybe it's not. But your narrow argument, which I'm supporting for purposes of this question, is just under Thunder Basin factors, under Free Enterprise Fund, and under Elgin, we're on the right side of the line because it's a challenge to the structure of the agency.
Right, and we're ultimately content to win either way, Your Honor. But I do think on Thunder Basin, one thing that the last almost 10 years has shown in the courts of appeals is that the Thunder Basin hasn't been particularly helpful to the lower courts in resolving these issues.
Right. I think when Mr. Clement said the beauty of the Thunder Basin factors, I definitely cringed because they have not been beautiful right. for the in the lower courts. But the wholly collateral, a challenge to the structure of the agency, is that one paragraph of Free Enterprise Fund kind of deals with that. Now you ought to respond to what's that other paragraph in Free Enterprise Fund, and how would you explain that? But
right, and I think
that seems simple enough. I guess what I'm challenging and pushing back on is kind of throwing it all open again after decades of trying to figure out how these claims should be sorted out. Doesn't causes me some concern, at least.
I guess I understand Your Honor's concern. I think it should be addressed by the fact that district courts have been applying the sorts of tools in determining when or whether to exercise jurisdiction for centuries. In Standard Oil, one of our friends' cases they like the most, is an example of how district courts can apply those tools. And I think, what we're talking about here is treating this case involving one of the most important questions of the court's jurisdiction differently than any other statutory interpretation case. I think what we would ask and hope is that this court make clear the involvement and preeminence of the statutory text in resolving these questions. I think the Thunder Basin factors can be complementary. In some respects, you could take, and Justice Kagan's question earlier, I think, alluded to this, is, one might plausibly interpret the reference to any final order to include a challenge to preliminary orders that wouldn't actually aggrieve someone until they were embodied in a final order. And in that respect, those sorts of claims would be channeled through the review scheme. But I think, here fundamentally, this case doesn't sort of fit cleanly within the Thunder Basin paradigm because we're not challenging the kind of agency action that is covered by the alternative review scheme. We're not like Elgin. We're not like Thunder Basin in that respect. We're challenging we're not challenging the final order. We're challenging something that is completely separate.
Yeah, and that's in that respect, just to add one more, you're like Free Enterprise Fund, and just if you can address the part of Free Enterprise Fund and that is
sure.
more problematic for you.
So we think that the better reading of that is that the court was just responding to the government's argument, and that Ms. Cochran is in the same position as the plaintiff in the Free Enterprise Fund case in the sense that the only way that she could guarantee that she could get to an Article III court to raise her claim is essentially to default in her administrative proceeding. In that respect, she does have to bet the farm because, although it's unlikely given the agency's track record, if she won on the merits, of course, we believe that she's in it, but if she won, she wouldn't be able to present her structural constitutional claim to a court of appeals ever. And again, just on the meaningful judicial relief, I wanted to emphasize this point that Mr. Clement made in rebuttal. Here, it's not clear that getting relief at the end of the day is going to be relief at all for this type of constitutional claim, because as the way to get relief for a structural constitutional violation is to immediately enjoin the agency proceedings so that you don't have to go through them. I mean, under this court's decisions in Collins versus Yellen, it's at least much more challenging to get relief retrospectively, which underscores why waiting to the end of the proceeding, years down the line, is not meaningful in the constitutional sense, much less in the practical sense.